Thanks so much, Megan. Thanks to LAC for helping organize and present this webinar. Thank you all for attending. We did turn off the chat function for the webinar, just given the number of participants, but people are more than welcome to ask questions, and I will try to answer those as I go or at the end, just depending on timing and everything. So as was mentioned, my name is Cory Hernandez. I use they, them pronouns. I'm a staff attorney at the Family Violence Appellate Project. We were the sponsor behind AB 2369 by Assembly Member Salas. We thank his office for authoring the bill. We thank everybody who worked on it, the bill, and supported it, submitted letters of support. And I especially thank my colleague Arthi Vasan here at FVAP, who helped work on it with me in great detail. So we'll get started. First, just a brief introduction with FVAP. So we are a nonprofit based in Oakland, but we're statewide in California and in Washington State. We work to ensure the safety and well-being of survivors of domestic violence and other forms of intimate partner, family, and gender-based abuse. We help survivors obtain effective free representation in appeals by collaborating with pro bono attorneys. We advocate for survivors on important legal issues, including through legislative advocacy, like with AB 2369. And we offer free training like this and legal technical support for those helping survivors, including attorneys and advocates. Our work contributes to a growing body of case law that provides the safeguards necessary for survivors and their children to obtain relief that they need through the court. I will note that these slides will be available. I believe we're putting in the chat where you can find them. I also have a PDF of the slides with my presenter's notes, so you can see some additional thoughts and citations. And a few notes for the slides. Just to note, AB is Assembly Bill. CCP will be used instead of Code of Civil Procedure. Family Code will be FC. DVRO will be used for Civil Domestic Violence Restraining Order. DVPA is the Domestic Violence Prevention Act, which governs DVROs. CRC will be used for California Rules of Court, and these slides may omit section and rule in citations. Brief agenda, sort of what we're going to cover today. First, we're going to cover some learning goals, go through a brief history of AB 2369 and the statutory changes that were made. We'll then go through some of the on-the-ground procedures needed to make a request for attorney's fees, and go through some of the determinations that need to be made, like ability to pay and a reasonable amount of fees. We'll then delve into a couple specific cases, like what if petitioner is only partially prevailing? What about respondents? What if there's a mutual restraining order case? And what if it's a modification or termination? Then we'll briefly talk about some potential issues that may be left for appeal or further legislative action. And then just as I mentioned, hopefully leave some time for questions, but folks are free to ask those throughout if you prefer. So brief learning goals. First, I want folks to understand the intent behind the bill. Second, I want folks to know the fees request process and the requirements for each party, both the petitioner and the respondent. Third, want folks to walk away recognizing how this new law in 2369 works in those specific cases that we mentioned. And fourth, anticipate potential issues for appeals so that you know when you're litigating how to lay a record for that if you need to, and how to argue that in the trial court as a matter of first impression. Would also note here that we do have additional free trainings that have been recorded on our website at FVAP. The link is in the presenter's notes. Most of those do have MCLE credit available as well, including things like how to lay a record for appeal, how to request a statement of decision, and just generally how does a DVR work, how do you write a declaration, things like that. And of course, want to shout out LAC for their other great recorded trainings on their website as well. So first, the history behind the bill, the statutory or the citation to the bill is in the presenter's notes. So before the bill, Family Code 6344, which governs DVROs, it's part of the DVPA. Before AB 2369, that statute just had two subdivisions, A and B. the subdivision A had basically always been there in the DVPA, and that basically just provided that the court may award attorney's fees to a prevailing party. It's pretty straightforward. It gave the court discretion to grant fees. It didn't list any factors or anything. It just said it may award fees to a prevailing party. It didn't distinguish between petitioner and respondent. In 2005, the legislature added old subdivision B, Family Code 6344, which was specifically for prevailing petitioners, not respondents, prevailing petitioners who, quote, cannot afford to pay. The difference between A and B, as I read it, was that A was for either party in any case. B was for a very specific type of case where a petitioner is prevailing who couldn't afford to pay their attorney for whatever reason. And it was worded differently. It wasn't discretionary. It didn't use may. It used the word shall instead. That in that way, it was mandatory. Family Code Section 12, which is a general statute, says when construing statutes, shall is mandatory and may is permissive. So here it was mandatory, but given how that old statute in subdivision B was worded, it was actually a bit more discretionary in practice, because it said the court shall award this prevailing petitioner who cannot afford to pay fees if certain conditions are met. So by adding those different conditions, those requirements that need to be met before the court has to grant those fees, it effectively gave the court that discretion back. So it was worded in a mandatory way, but actually in practice, it became very discretionary because the court had to consider whether the petitioner cannot afford to pay and whether the fees are, quote, appropriate based on the respective incomes and needs of the parties and any factors affecting the parties' respective abilities to pay. So that goes beyond just whether the party ordered to pay fees has the ability to pay, which always comes into play. Family Code 270 has been in effect for years, and it applies to any attorney's fees order in the Family Code, including 6344 DVPA attorney's fees. So that ability to pay was something that was needed both before AB 2369 and after. But before AB 2369, this subdivision B also added these other factors for a prevailing petitioner. And so you may wonder, well, if subdivision A and B are different, then why is it a problem? It was a problem in part because courts collapsed subdivisions A and B together. And since subdivision B only applied to petitioners, prevailing petitioners, not respondents, they effectively added those additional requirements, those factors in subdivision B as consideration for whether to grant a prevailing petitioner fees, but did not consider those additional factors in subdivision B for prevailing respondents. So what we were seeing before AB 2369 was that courts were making it harder for petitioners to get fees than respondents, which is not at all how the law was intended to work. But courts just kept pointing to the subdivision B to say, well, we have to take all this into account. And so a lot of courts would deny fees to prevailing petitioners for lack of, quote, need. We would see explanations like the survivor was able to, take out a loan and go into debt and get fees. The survivor is able to borrow heavily from their friends or family with, limited expectation of having to pay them back or not having to pay them back immediately. Things like that. Or the survivor could work more. The survivor could do any number of things, basically. So we would just see it very often where the court would be denying fees to prevailing petitioners who actually really needed it. So that's part of why we move forward with AB 2369. So we wanted to make it easier for petitioners and survivors. We wanted to make it harder for respondents as abusers. We wanted to still have an intent to deter frivolous or abusive requests. As we'll talk about, we have some language in the new statute that talks about that, including we want to deter cross requests or retaliatory requests for DVROs that abusers file after a survivor files first, or early unnecessary requests to modify or terminate a DVRO. In wanting to implement these purposes, we looked at other statutes in California that had similar goals. And so that's why we wanted to match other remedial statutes. So we looked to the Fair Employment and Housing Act, FVAP, Anti-Strategic Lawsuit Against Public Participation, Anti-SLAPP statute, and the Political Reform Act. And you can see in the presenter's notes in the slides, there's some cases there that talk about the purposes of those statutes, those other remedial statutes. You can see how they map onto us in analogous ways. Would also note the legislative history is cited there in the presenter's notes, the committee analyses, which are very useful, I think, as well as there on our website, we have the letters of some of the letters of support that we submitted as sponsors and that others submitted. Of course, whether or not a court, or to what extent a court considers these different pieces of legislative history persuasive or not, you have to check your current court, your local court in your district, depending on where you're practicing. Different courts have different, give different weight to different types of legislative intent or legislative history as far as what is the intent. Okay, so now with the new bill, effective January 1st of this year, instead of 2 subdivisions that were, I think, a bit confusing, we now have 3 subdivisions that I think are a bit more straightforward, although there's still, as we'll talk about at the end, some potential ambiguity or confusion that may be needed to work out in further legislation or appeals. So we'll talk about subdivision C in a little bit, but first wanted to focus on A and B. So A now is for prevailing petitioners and B is for prevailing respondents. You'll note that A is mandatory and B discretionary, as we talked about Family Code Section 12, talks about the distinction. So subdivision A is for prevailing petitioner, and that is mandatory. There's no list of factors the court has to consider. Those factors from old Family Code Section 6344 are gone. But the court would still have to consider the party order to pay, their ability to pay, as we'll talk about later with subdivision C. And then for a prevailing respondent in subdivision B, that uses the word may, so it's discretionary. It's up to the court's discretion if certain conditions are met. So if the court finds that the request was frivolous, we'll talk about what that means. Or if the request or petition was solely intended to do one of these following things: abuse, intimidate, or cause unnecessary delay. And we'll talk about what those mean later. Just to know, I may refer to these subdivision B elements as the 6344B elements. So what needs to be met for a respondent to get fees. So now that the law has changed since January 1st of this year, we have removed that ambiguity that I had explained between subdivisions A and B. There's now no longer a need to show fees. And because of, I should back up a little, because of that ambiguity that I was talking about between the old version of 6344 and A and B, because that seemed to allow courts to consider not only the ability to pay of the party order to pay, but also the ability to pay of the party asking for fee, the petitioner in particular. The Judicial Council had, up until recently, required that the petitioner to seek fees had to file an income and expense declaration. You will note, though, the California Rule of Court, I'm sorry I don't have it right in front of me, but in Title V in the Family Law Rules that talks about requesting attorney's fees, it lists out the statutes that that rule applies to. There's Family Code 2030, 7605, some of those other family law ones, but it does not include 6344. So actually there is no state California Rule of Court that has ever required a petitioner in a DVRO case to file an income and expense declaration. That was a requirement the Judicial Council added to the DV100 form. So petitioners had to file that. And I think some local courts may have also had local rules to that effect. But as I said, that wasn't in the statewide rules, and that wasn't actually in the old version of the statute. But because of that ambiguity, some people interpreted it that way. That ambiguity is no longer there. And as I said, the statewide rule still does not require it. So the petitioner should not have to file an income and expense declaration to get fees in a DVRO case. I can say the council is right now working on revising the DV forms to implement a few different bills from last year and some other changes that I believe are going to go into effect January 1st of next year. And part of those changes is that they're going to remove this requirement. My understanding is that they're going to remove this requirement for the petitioner to have to file income and expense declaration on the DV-100. But do want to say, if you're seeking, if you are a petitioner seeking fees under the DVPA and another statute, those other statutes may have different requirements and different standards. So you may have to file an INE for that other statute to get fees. I have some case examples in the presenter's notes that have examples of distinguishing between the different types of cases. If you have a DVRO that's filed in, say, a parentage matter or dissolution, or DVRO has custody attached to it or something like that, you may be able to get fees for different parts of the case depending on the issues that are being litigated. We have on our website a case annotated compendium of case law that includes all published DVPA cases, including those on 6344. There aren't many on 6344, I'll be honest. We'll talk about a couple of them. Hopefully with this new law, with the language maybe being clearer in my view, maybe that'll get more people litigating the statute and get some more case law to see what exactly the contours are. So other notable changes, as I said, subdivision C is also there. We did not need to add subdivision C to the statute, just want to be very clear about that. Whether or not that language was there, Family Code 270 would still apply. As I said earlier, Family Code 270 affects all attorney's fees orders in any family law case. That's what the statutory text says. But what we were saying before AB 2369 was that some courts, especially with newer judicial officers, dealing with mostly pro per or self-represented litigants, may not know about 270 or may not know how to apply it properly. And so some courts weren't taking into account ability to pay. And actually, we were seeing it a bit often with survivors whose requests were denied, and the respondent would seek fees, because more often than not, research shows that in DVPA cases, most litigants are self-represented, but for those who can't afford an attorney, it's usually the respondent, the abusive party. And so we were seeing a lot of cases where the court would be ordering a survivor to have to pay the abuser their fees without taking into account the survivor's ability to pay. So we really wanted to just hammer home this cross-reference to 270 just to make sure courts were properly considering that. And then I also wanted to note, just in subdivision A and B, we intentionally added the language upon request. I don't believe that was in the prior version of the statute. I don't know if it's actually technically needed, but we really just wanted to make sure that courts wouldn't be making any sua sponde orders on their own motion. It's questionable whether they have that authority anyways, but just in case, I've seen family, in my work at FVAP, we've seen plenty of cases where judges do things for all types of reasons, whether or not the law supports it. So I would just say, we wanted to be clear that we wanted to keep the autonomy with the parties, especially with survivors. And we don't want courts, ordering, say, an abuser to have to pay a survivor if the survivor thinks that may be risky or dangerous, or may detract from the abuser paying for maybe support or something else. I do think, because the statute just says upon request, in my view, again, this is all, this isn't necessarily the definitive answer on everything for the statute. This is sort of just FVAP, or my point of view, what we would argue with some citations below. But in my view, it should be sufficient to have an oral request because that's all the statute requires. However, definitely want to note, check your local rules. You may have to file something in writing, and it's always, in my view, and I think it's best to try to get something in writing, have a clearer record, especially nowadays when court reporters are less frequent in family law actions and DVPA actions. it's best to get things in writing. It just helps for further modifications and appeals and stuff like that. So yeah, so now the procedure for going through the request itself. Wanted to briefly mention, so a question we've already gotten before this training itself, but I'm sure others have, is, so say you have a DVRO case that was decided last year, November, December last year or whatever, and an attorney's fees request is being heard now. Would the new law apply or the old law apply that was in effect at the time the DVRO decision was made? In my view, the new law should apply because it's the law in effect at the time this decision is being made, and the attorney's fees decision is a separate decision after the DVRO itself. And there's some citations in the notes below for that. And I also wanted to note that this does apply to appeals. And there's a case that talks about that because in general, statutory prevailing party provisions generally apply to appeals as well, unless they say otherwise. And then also give a couple examples. As I said, there's not a lot of 6344 case law, but there are two down in the presenter's notes. There's the Loeffler versus Medina case. I believe that, I don't know if I'm pronouncing that correctly, sorry, but that's how I say it. That is a case where a respondent or restrained party tried to terminate a restraining order early. And the court found that actually a frivolous request. So that actually presents a good example of frivolous request to end a restraining order early, and that talks about the old version of the statute. Notably, Loeffler just talked about subdivision A of the old statute, did not talk about B, which is, I think, confirms my view that there are two independent provisions, but people, again, viewed it differently earlier. And then also just wanted to note, SA versus Maiden is another case from 2014, which talked about how 6344 is one example of a family law statute that can be used as a sanction. And I think, those types of intents, that language about intent behind the fee provision and stuff like that, I think even though it's construing an earlier version of the statute, to me, that should, that type of reasoning should apply even now. Somebody asks if this would apply to renewals. Yes. I apologize, I did not expressly list renewals in earlier, but yes, everything we're talking about applies to any aspect of the DVRO process. So, and what I call the initial request, which is, you file the TRO, you go to the restraining order after hearing stage, and that's the initial request. It would apply to modifications and terminations. We're going to talk specifically about those later, just because there's some language about how those might work. And it would apply to renewals. I didn't specifically call out renewals because I don't think it would work differently with renewals. It would basically work the same as an initial request type of thing. And I do believe the Judicial Council is considering amending the renewal forms, the DAD 700 and 720, to add boxes so that you can ask for attorney's fees. But as we'll talk about later, even without those boxes on the forms themselves, you could still ask for those. Yes, so somebody also asks if this law would apply to nonprofits. So absolutely yes. There is a lot of case law, including California Supreme Court case law, that talks about how courts should treat nonprofits pretty much the same, with the understanding that even though the nonprofits aren't being paid directly from the client, by ordering attorney's fees for them, the court is effectively furthering the mission of what they're doing, their litigation for other clients as well, so that they can keep up their work. As I mentioned, FVAP's website has a case annotated compendium, which is a case law compendium. In there, we have some of those cases that there's like in remarriage of Wood, I think, and some others that specifically holds that yes, it applies to nonprofits, and also applies to pro bono attorneys. So if you're a private law firm working for free for a client, you can also get fees for the same reasoning. It is true, as this person mentioned, asking that courts may be more hesitant because there's no financial burden on the litigant. But I think then you just need to quote from those cases that I talked about, and really hammer home that courts need to be treating them the same, given this understanding. And given that the statute itself, especially if it's for a prevailing petitioner, doesn't talk about the need for the party asking for the fees, right? We got rid of that ambiguity, that problem from before. So hopefully I answered that question as well. Somebody also asks, so I earlier talked about, so here on this first point, if the restraining order was decided back last year, but the fees request is being heard now. But what if the request for the fees was filed earlier? So like last December or something, so last year, but it's being heard now. I still think the new law should apply, and I would check out the citations I have in my presenter's notes. One, there's a family code section 4. For those who don't know, for those practicing family law, it's generally a good idea to also look at the earlier provisions in the family code, the general provisions, the definitions stuff, because they have some interesting language that can be useful. Like family code section 4 talks about how different new laws apply to pending cases, and there's some cases that interpret this. But basically, yes, it's a remedial statute, so it should be applied to any pending requests at the time the decision's being made. And somebody asks if we'll be creating any model sample MPAs on these requests. Yes, thank you for asking that. So we do have already, we have this training and we have a new law alert, which is like a 3 or 4 page document that walks through the changes to the law and actually gives more charts. So if you're more of a visual learner, if you need something more just compact in one place, I would suggest checking that out as well. But yes, we are working on sample MPAs, both for the petitioner and for the respondent. They will be a bit bare bones, just because we want to give space for people to ask, to fill in their own case facts and procedures and everything. But also there could be some differences depending on whether it's a mutual case or a modification, and as we'll talk about later. So our models are going to be sort of bare bones, just for either side, unilateral, and folks can add into it as they need to. Awesome. So the procedures, as I said, you have to make the request. You can make it on the judicial council forms themselves. Right now, it's just on the 100 and the 120. But as I mentioned, there is a case that specifically holds that even if you don't check the box on the 100, you can still file a request later. The FL 300 could do. As I mentioned earlier, I personally believe an oral request should be sufficient, although I would definitely caution just to make your record, written requests are best. And of course, your local rules may say differently. And then the deadline, here's the rule of court for figuring that out. It's basically the same as the appeal deadline. And if you're interested about that, I would note that FVAP has a resource on our website for calculating your notice of appeal deadline. It's a 1-page sort of decision tree flowchart where you just answer yes or no to different questions, and it helps you figure out your NOA deadline. Judicial council forms, the website for finding those forms is on the presenter notes. And then after you make the request, you have to give notice to the other party and then have the hearing. The court could decide your request for fees when it decides the restraining order, if there's enough time and if the court has enough information, or as we were talking about, often the court will decide a fees request afterwards. And then of course, check your local rules for any additional procedural or other requirements that need to be made. Ability to pay. So this is a discretionary determination. This is, now we're going into subdivision C of the statute, 6344, which is also 270. It's about discretionary, about ability to pay. This is discretionary. These points on the slide here are all taken from different cases that are in the presenter's notes. So for determining the ability to pay, the court can look at the actual income, debt, property and assets owned by the party, order to pay, the obligations that they need to meet, the ability to earn, recent sales, and other things. They can base the ability to pay determination on the testimony of one party or witness alone. They can presume that the party will work or be self-employed to cover basic expenses. And I wanted to note, so most Family Code 270 cases The published cases I've reviewed are only useful to a point, as I talk about in the presenter's notes, because they often interpret not just 270, but 270 and another statute like 2030 or 7605, or there's the child custody or child support ones. There's a bunch of other ones that are very different from 6344 because those talk about the respective needs of the parties. Those are need-based. This is prevailing party-based. So a lot of the 270 cases that I cite to, or that you may look to, just be careful about how you review them so that you're only pulling out the 270 pieces that correspond to 6344 and not the 270 pieces that correspond to other statutes that aren't applicable. And as I said, hopefully now that 270 is specifically called out in the statute, we can start getting some 6344 case law itself that also deals with 270, so that now we don't have to have this caution anymore, and we can look to 270 case law that's just about the DVPA. Oh, somebody asks a question about mutual restraining orders, and whether the party then, if they're a petitioner, then the other party files their own request. Now the first party who filed is now a respondent. We'll talk about mutual restraining orders in a bit, get to that. Hopefully answer that question. If not, please ask that again. Thank you about that. So what is a reasonable fees amount? Again, sorry, this is discretionary. These points are from the cases cited below in the presenter's notes, but basically the court can consider a whole host of things, including the rules of professional conduct and what would be a reasonable fee agreement. Court can look at the nature, difficulty, and the amount of the litigation, the skill and training required and employed to try the case, success ultimately gained, and we'll talk about partial success, as I mentioned. The experience, age, and education of the attorney, intricacies and importance of the litigation, and the time needed to take the case. Okay, so now we're going to talk about some of those specific cases, get some more into the nitty-gritty of how this, again, my understanding, my view of how this may work or should work. So first, if it's a partial win. So as I mentioned, we styled AB 2369 after other remedial statutes. So to understand the intent or purpose behind it, you can look to those other statutes. For instance, this first point is taken from an anti-SLAPP case, where the court was saying, even if somebody's partially successful in an anti-SLAPP case, if they were able to say, in that context, strike only some of the causes of action, but not all of them, still the court should give a broad interpretation to a prevailing petitioner because of the intent to award them fees and make it easier for them to get fees. So what would a partial win look like for a prevailing petitioner? Well, that could be if the court grants them, a DVRO, what some call, just a straightforward standard DVRO, a basic DVRO, whatever you want to call it. The typical or usually no contact, no abuse, stay away orders. But maybe the court denies other relief like financial restitution, support, property, attorneys, sorry, not attorneys, battery intervention program, cell phone transfer, any number of other types of relief. To me, that would still be a partially prevailing petitioner. Or the court could find abuse happen, but then deny the DVRO. And this is actually in a case cited down in the presenter's notes, because the DVPA statute, Family Code 6300, subdivision A, uses the word may. So it says the court may grant a restraining order if it finds a past act or acts of abuse. So technically a court could find abuse happen, but still deny a DVRO. To me, that would still be a partial win for most petitioners, because the finding of abuse can be useful for them for any number of reasons, whether for custody, support, or if the abuser files a retaliatory request or something like that. So still having that finding can, to me, be useful and prevailing. Or the court could deny the restraining order, whether or not it finds abuse happen, but then maybe grant other relief. So for those who may not know, there are some of the statutes in the DVPA, specifically like 6341, is not tied to the court granting the restraining order. And there's a case, Marriage of JQ and TV, that talks about this, where the trial court denied the restraining order and denied a spousal support request because it said it couldn't hear the request since the restraining order was denied. The Court of Appeal said no. The statute's written such that you have to decide that anyways, even if the restraining order is denied, because of the financial need for the party and the support that is needed. So take a look at that if you have that type of case going on, to see if he's still maybe partially prevailing. So if you're partially prevailing, how do you determine, what amount to ask for? How do you determine that? It's again, looking to other analogous cases, since this is the new law. One thing you may ask, this is taken from a different type case, is, were the results so insignificant that your client didn't achieve any practical benefit from bringing the request? This practical word may be good to use. So basically, you're looking at whether or not your client got a practical benefit from that win that we talked about in the last slide. They could still be considered prevailing party. And there are different ways for determining or defining or describing a prevailing party in the cases. As with a lot of legal terms of art, different courts like different formulations, different words. So just kind of look around and find a case that's a bit more on point for what you're looking for and has good language that you like. And then, of course, the fee award, even if you worked, spent $10,000 working on a case, if you are only partially successful and say only half of your time went to that issue that was successful, I think it would be reasonable to reduce your fees in half, right? Because you only spent $5,000 on the actual issue that you were actually successful on. So you'll basically have to keep track. This is like with any other type of case where you're partially successful on some issues and not others. Just have to keep track of your time on the different issues that you're presenting. And just like when you're dividing up time, we talked about earlier, if you're seeking fees under DVPA and other types of statutes like Family Code 2030 or something, you have to keep track of your time depending on the statute that you're seeking. You may also have to keep track of time depending on the issue, if you're able to do that. Okay, so as a respondent, for a respondent, for them to get a total win, it would basically be, in my view, no restraining order issued, no abuse finding, and no other relief granted. And then if that happens, they may get fees if they meet those other 6344B elements that we talked about by preponderance of the evidence, which is the default standard under Evidence Code 115, but is also expressly included in the statute, just because some courts don't know about the default standards. So those elements are listed here on this slide and the next. So they have to show the request was either frivolous, which is an objective standard based on the reasonable attorney. There are, as I said, with legal terms of art, there are a lot of different formulations for the language used by courts on how they describe it. Some say totally and completely without merit or for the sole purpose of harassing an opposing party. Others use words like groundless, unreasonable, vexatious. To me, then, it could be reasonable to look at the definitions of vexatious litigant in the CCP 391. That could be another analogy to draw. There is a statute, CCP 128.5 subdivision B2, that has a definition for frivolous, but just be careful. That statute also has other procedural and substantive requirements for seeking fees under that statute in particular, and just has a useful definition for frivolous. So just be careful on how you use that statute, in some cases applying it. And then, so either those 6344B elements are either frivolous or solely intended to abuse, intimidate, or cause unnecessary delay. Solely intended, so that was, that's a subjective determination, which can be inferred from the surrounding circumstances because somebody's state of mind can be quite hard to prove. Abuse is as defined in the DVPA itself in Family Code 6203 and 6220. intimidate or cause unnecessary delay. I'm hoping that's plain language enough. Or you can maybe look to like dictionary definitions, or it may be this is something we need some cases about. And I've also note there is a case, a recent case in the presenter's notes that talks about the differences between objective and subjective standards and compares in one statutory scheme frivolous to bad faith. Frivolous being objective, bad faith being subjective. But then no, bad faith is not used here in 6344. Okay, so mutual DVRs. Before I get to that, just there is a question asking if there's whether I think it's a realistic possibility the judge denied your client a restraining order, but then awards you prevailing party fees. Again, it's possible, especially under the new statute when now it uses the word shall and it's mandatory. If you are able to prove that you have a practical benefit, even if the restraining order is denied, for instance, if the court denied your restraining order but grants you spousal support, it may be that you spent most of your time and most of your litigation on the restraining order piece, and you only spent a very small fraction on the support. So you may only be able to recover a small amount for that issue that you prevailed on, but maybe something's better than nothing. And ultimately, that's the type of thing that maybe we'll need to have case law on to further just get an appeal on to decide that. But yeah, it's not discretionary anymore. Is kind of the answer there. So I think it is realistic. It's possible, but you know your judge best. You know your local court best, and you know what arguments and facts you need to present to make the best request you can. And again, to lay the record you need. If you know you're going to lose on that request, you may just want to make the record for an appeal. You can do that. As I said, we have a training on our website for laying a record for appeal, as long as your client's okay with it and understands what you're doing and everything. But yeah. So for mutual requests, so I put a chart here. This is on that handout I talked about for the new law alert, but hopefully it makes some sense. So just as we were talking about, if you're seeking fees under the DVPA and another statute, you have to divide up your time between what you're focusing on here and what you're focusing on there. If you're depending on the amount you're going to be asking for and the requirements you need to meet to get those fees, or if you're requesting fees as a partially successful party, you have to divide up your time between the issues that you succeeded on and those you didn't. Just like those here, if you have a mutual request and you prevail on one but maybe not the other, or you prevail on both, you may have to divide your time depending on which case you're talking about and which side you're on. So we'll just go top left. So if your client YC wins and the opposing party OP wins, so you're both prevailing petitioners and should get fees for winning their own cases. Subdivision A of the statute says shall award fees for prevailing petitioners. They're both prevailing petitioners, even if they're only partially win, as we were just talking about. So if the court finds they both abuse each other, but doesn't issue either a restraining order or grants them some but not all the relief they requested, they could still be arguably prevailing in their own cases and should get fees, but maybe at a reduced amount. And especially with mutual restraining order cases, it's even more likely or even more possible the court could deny the restraining orders after finding abuse, because 6305 of the Family Code adds additional requirements for the court to issue a mutual restraining order that adds additional factors the court has to take into account, which are not there for a unilateral order. If your client wins, the opposing party loses, your client would get fees for prevailing in their own case, and they may get fees for defeating the other party's request if they meet the other elements, 6344B elements. So they'd be the prevailing petitioner in their case, prevailing respondent in OP's case. If your client loses and the opposing party wins, the opposing party, it would be flipped. They get fees as a prevailing petitioner in their case. You may get fees, and they may get fees for defeating your request if they meet those other elements. But then say you both lose, you would both then arguably be prevailing respondents. So you may get fees, discretionary, for defeating the other's request in their cases if you meet those other 6344B elements. Um, our case annotated compendium on our website has all the published case law in 6305. And the new law alert has some other charts that may be useful. So modification termination, this should be understood. The statute right now just says petitioner and respondent. Unfortunately, this is one area where we may need further legislative action. But my understanding, or how I think it should be construed, is that petitioner means protected party, respondent means restrained party. So if a protected party defeats a restrained party's request to modify or terminate the restraining order, they should still be considered the prevailing petitioner. That would be like that Loeffler versus Medina case that I talked about. Or if the restrained party successfully modifies or terminates the restraining order, they would be considered prevailing respondent. There are very few modification termination opinions, and there's only a couple judicial council court forms for that, because they expect people to use the FL 300. There's the DV 400 info, which talks about this process, but note that there is some call from some in the field that want the council to adopt a form specifically for modification termination. And maybe they may do so, who knows. So wanted to identify just some potential issues for appeal, or as I said, further legislative action even, as we're getting here near to the end. This is the last slide, and then we'll have questions. If folks have any more, please feel free to put them in the chat or the Q&A. And if you asked one and I did not answer it fully or to your satisfaction, just let me know. So potential issues. So, one thing could be who's prevailing, as we're talking about. If the petitioner only wins in part, we'll likely need some case law to help establish what that exactly means, looking to some of those considerations that I was talking about earlier. We'll also want to see who's prevailing, sorry for the misspelling there, in a modification or termination request, as we were just talking about. We'll probably need some legislative action or appeals there. How does Family Code 270 interact with 6344, given that the other 270 cases interact with other statutes? This one is quite different and intentionally different. As we were talking about early on in the training, does this new law apply to a pending fees request when the restraining order is decided before the law went into effect? There is a unpublished case from, I believe, the 3rd district, a recent one just a few weeks ago that held this issue, that ruled on this issue and held that yes, the new law applies to a pending fees request, even if the restraining order is decided before. It's Marriage of Singh and Randhawa from the 3rd district. I'm sorry I don't have a citation. Like I said, it's unpublished, but it can sometimes be useful to look to unpublished decisions to see their legal reasoning and their citations, and you can use those in your own writing maybe, even though you can't cite to unpublished California decisions in California courts. But yeah, so we'll need some more clarification about that. And then lastly, we'll need clarification for what cases look like for whether the 6344B elements have been met. Those elements being whether the request was frivolous or solely intended to abuse, intimidate, or cause unnecessary delay. What exactly do those mean? How do you show that? I'm guessing a lot of those types of requests that type of showing is going to have to be made with circumstantial evidence. So we'll need some case law to help, give guidance on that. And even if those elements are met, how the statute's worded in subdivision B, it still says may. Subdivision A for petitioner says shall and doesn't have those factors that have to be met, but subdivision B for respondent says may and does have these factors. So how I read the statute and how I think we intended it was, even if those elements are met, we still wanted to give courts some discretion just in case there may be other factors affecting the decision that may not be expressly listed there. So just because those 6344B elements have been met doesn't necessarily guarantee you would get fees as a prevailing respondent. It just opens that door. But then we'll need to determine, maybe through cases or something, what exactly does it mean for a court to abuse this discretion if it were to deny fees if those elements were met, right? because I've seen cases, especially when I used to practice at trial court, and I had represented survivors who were. I had a client where she got a restraining order, and then the next week their abuser filed his own, and just attached the same declaration he had filed to his response to our requests, to his request. And we pretty easily got that defeated. And then actually that was one of the only times as I was working at a public interest organization, a nonprofit. And that was one of the only times we actually sought attorney's fees, which was specifically because we wanted to deter further frivolous requests from this abuser. And we were granted fees under the old statute. But in doing so, we really intentionally tried to show that it was frivolous. We pointed to the same declaration, the same arguments he was trying to make at the hearing, that type of thing. We tried to show the litigation history. So, there are ways that you can show it. But yeah, so just saying that it can happen. That said, I have a few minutes left. If there are any questions, please feel free to put them in the chat. As I said, we have a free technical legal assistance program for advocates and attorneys helping survivors for free. Email or call us there. We also have a separate survivor helpline, so clients, potential client survivors are welcome to reach out to us. We still have our office. We're mostly closed still now with the pandemic, but if you want to meet with us in person, just contact us and we can arrange that. Of course, this is legal advice, this is not legal advice, just information for you, from my personal opinions, not replace the advice of an attorney. And this is only using California law, just last updated yesterday. If you, I think, sorry, just checking the chat. So Brian and Jenna, I hope I answered your questions, and those who, Sarah, Carrie, and others in the Q&A, hope you answered. If others have questions, I don't know if you're able to unmute and ask. I mean, you're welcome to. Slides will be available. Thank you, Sarah. I believe LAC will be posting those in the chat or emailing them out to folks who registered. So even if you're not able to make it today, they'll send out the recording, the slides. Hopefully also the, oh, thank you. Yeah, they're in the chat. There's the slides, the actual PowerPoint slides themselves, and a PDF of the slides with the presenter's notes, and the new law alert that I was talking about, which is like a 3-4 page document that has charts and kind of talks and has all these citations and everything as well. So hopefully you can pull from that. And then as we'll send out information when we get that template, those templates up for requests for their petitioner and respondent up on our website. Probably, to be honest, it's going to be a little while, just given some other work we have to do, but we're really hoping to do that soon. If others, I should say, if those on the call, if you have requests that you think are great or might be useful that you could redact, or if you have templates or something and you want to send them our way, that's our contact. You're more than welcome to contact us and share with us what you have, and we can use that for our templates or something. Oh, sorry, so another question. Does FF has, oh, sorry. Minty asked a good question. So if a survivor is asking for our help with their case and they want us to take them on for an appeal, or amicus, I forgot to mention that on my slide, but we'd also do amicus work. They can contact us either through phone or email. Either way is fine. It would be the email up here, info@FVAP Law. We just use that because that is checked by multiple people, so that if somebody's out or something, then emails aren't getting lost, and we want to stay on top because we get a lot of these, especially that's what we use for client communications. So that's helpful. Thank you for those who had great things to say in the chat. Oh, question, does FVAP have specific guidance for attorneys' fees requests when we prevail against an attempt to terminate an RO? Yeah, so I think that would be, that's a great question, Mia. I don't think we'll have a template specifically for that, but you should be able to use the template that we're gonna get to basically fashion your own. Like I said, the ones that we're going to make are probably just going to be unilateral requests, sort of like just a straightforward petitioner, straightforward respondent on their initial or renewal requests, just because that's sort of the bare bones, and frankly, kind of easier on us instead of having to do like 10 different templates on all the, because there's so many different scenarios you can think of, right? Whether it's mutual, whether you're partially prevailing, whether, you know, so many, or whether you're seeking for other statutory fees as well, like if you want DVPA and dissolution and parentage fees. So there's so many permutations of what can happen that we're just going to have two straightforward requests and hope that people can build on it as they need to, basically. But for this question, Mia, yeah, for a termination request, I would look at the new law alert, look at these slides for specifically here, you know, where we talk about if a petitioner defeats the termination request, I would still say they're the prevailing petitioner as a prevailing protected party. And you could cite to the Loeffler versus Medina case for that, where the trial court awarded the protected party fees for defeating that restrained party's request, and specifically noted that it was frivolous. Good questions, good question. And yeah, if you want to contact me directly, you can use the info@FVAP Law. I should have put my personal email, but believe I can, yes, I'll put it in the chat as well. So you can also reach out to me directly if you have questions. And I think that's all the questions that I see in the chat. If anybody else has others, please bump them up or let me know. And I thank you all for your appreciation and for your time, and for very, very deeply appreciative of all your the work and time you do for survivors. There's a lot of work left. Sorry, I'm just trying to make sure I got all the questions. I think that's about it. So thanks. I think, oh, there is an evaluation that'll be going out to registrants. It should also be in the chat along with the materials. Please fill out that evaluation just so I can, you know what works and what doesn't, and LAC can know as well. And of course, for your MCLE. 1 hour of general MCLE for California attorneys. So hopefully this helps. Thanks. I think that'll be it. Hope you all have a good day. Bye.
Thank you for joining us for today's webinar. This webinar was hosted by the Legal Aid Association of California, also known as LAC. We are the membership organization for California's civil legal aid nonprofits. Our job is to advocate in the legislature, in the courts, and with the State Bar of California on behalf of the community of nonprofits that serve low-income Californians. In addition to our online and in-person trainings, LAC provides coordination and advocacy for increased funding to support organizations like yours. Thank you.